Greetings, everyone. This is a call to action for all sovereign souls of light. Dear beloved Creator of all that is, peace and calm are needed now. The shock of disclosure has started. We gather as sovereign souls of light under the protection of the Creator of all that is to work for the greatest and highest good of all. We call forth the golden, white, pink light of the Creator of all that is, the cosmic diamond violet fire, the cosmic diamond white fire, and with the above energies and our love, we embrace all the unawakened people of Earth to instill calmness, peace, great patience, stillness, understanding, forgiveness, and awakening as they hear and see disclosure unfold in a very intense manner. We also send the above energies with our unconditional love and forgiveness to all the dark souls in, on, and above Mother Earth for their awakening and peaceful surrender. With each breath, we constantly send the above energies of the Creator of all that is, our love, light, peacefulness, and calmness to the entire population in, on, and above Earth. Our greatest calling now is to anchor love and provide loving support to all on the path of awakening. We pray peace, calm, love, harmony, and balance for all. We trust the divine plan, and so it is.
Thank you, Charlie.
My pleasure.
My name's Ron Vroman. I'm the old man talking head, the white guy for the Oregon Statewide Jural Assembly. I'm here with several others on the microphone and two others on video. Charlie and William, would you introduce yourself? The ones on microphone are Ray, Henry, Cheryl, and Cynthia. If I missed anybody, I'm sorry.
I'm Charlie White, and I'm the white gal because that's my last name. My mom always said by name and by nature, at any rate. I'm glad to be here. We have meetings every Monday evening at 7, and anyone is welcome to be on our calls. And I like to kind of see what's going on with all of us and keep us all on track.
I'm William Appel. I'm in the Portland, Oregon area, or on the Portland, Oregon area. I work on the technology, TV show, websites, that kind of stuff, gathering people together, both sides of the aisle.
What we're going to talk about this evening is, let's see, yeah, that show's pretty good.
Mm-hmm.
The formal challenge to the 12 presumptions in law. From personal experience at two of my trials, I submitted my rebuttal to the presumptions in law in both cases and had it filed into the record. It's really important, and you should do your best to not get into their de facto court. And William has a good piece of information from the Red Book that he might share with you now. You're under the bus, William.
Well, the information I got was from Jim Wright, and it's the red folder. And in the red folder, it has a list, an index of items inside the right side. The instructions say to use when you're in the courtroom. And basically, you keep insisting on assistance of counsel until they give you assistance of counsel. And usually what they'll do is they'll appoint you a court-appointed attorney. At that point, you give them some of the stuff that's on the index list there for them to fill out. And apparently these things are so powerful that the attorney will refuse to fill them out because he will be in fear of loss of his license and bar association. And then you will, then once he refuses to fill it out, then you fire him on the spot, maybe right there in front of the judge. That would be appropriate. And then you're without assistance of counsel again. So you keep doing this until they finally throw the case out of court because they can't do anything to you without assistance of counsel.
Yes.
And I will add to that there's an attitude that we must have if we're in their court. First of all, the presumption of the people is that, and that is us, is that we are persons or we are U.S. citizens. No, we are the people. We are powerful. All power is inherent in the people. And if we are in the court and we're assigned an assistance of counsel, we can simply fire them. They work for us. And we act as if we are their employer. So it's a really important attitude to have. I yield.
Yeah, I agree with that 100%. So what we're dealing with here is definitions of presumption, and that gives an Oxford Dictionary website. I'm sure William will post that, so if you want to look it up. And the guy that wrote this is named John Smith. There's, 40,000 John Smiths or 400,000 John Smiths? But in any case, somebody wrote this. And it says, number one, an idea that is taken to be true on the basis of proper probability. That's what a presumption is. As a presumption, it is a presumption on which must be agreed by the parties to be true, then and equally. If one party challenges the presumptions to be true on the basis of probability, then all that is required to remove the presumption is a formal challenge to the presumption. The presumption then has no standing or merit in fact. I presented to 2 courts of record in the de facto a rebuttal to these 12. I was found not guilty on one and I got my gun back. I was found guilty on another one and did 2 years probation. And I was found guilty on the third one and did 20 days and 3 years probation, reduced to 18 months. But in any case, number one, the extent to which something is probable, the likelihood of something happening or being the case. By definition, then, this is not substantive, as it is only a probability of what may be, and therefore has no substance in matter of fact. A state court does not operate according to any true rule of law. That's absolutely true, except for ours on Oregon. We are a lawful court. But by the presumptions, the color of law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become fact and are therefore said to be true. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor beneficiary, agent and agency, incompetence and guilt. Number one, the presumption of public record is that any matter brought forth before a state court is a matter for the public record, which is, in fact, presumed to be a member of the private bar guild, that the matter is a private bar guild business matter. Unless openly rebuked and rejected by stating clearly the matter is to be upon the public record. The matter remains in private bar guild matter completely under the private bar guild rules. Do you guys understand that?
Well,
Okay, you heard people
it,
say that we were in private. A guy we were talking to named Ray the other night. He said we stay in the private. Well, the bar stays in the private too. They stay in the private bar guild jurisdiction unless you rebut it. So
So how do
so
you rebut it?
yeah, that was
I'm sorry.
John Smith, the undersigned, formally challenged the presumption of public record as it is by definition a presumption and has no standing or merit, presentable or material fact. Bingo. All he did was rebut it. Just the same as what we do in all of our documents. We give the DAs and the Attorney Generals and Department of Justice, the FBI, and all of them an opportunity to rebut. And they don't rebut. They acquiesce to what we say. Same here. They make this statement. If you don't rebut it, you acquiesce. You only have to acquiesce to one of the 12. And if you're silent, you acquiesce to all of them. Number two, what?
There is no bar guild since 2012.
Yes, I've heard that before, Henry.
Prove me wrong.
Well,
For some reason, they're still out there.
they're still holding court. They're still putting people in jail. And whether it's lawful or not doesn't seem to pay any difference to them because they act illegal. But
in
in
color
any
of law.
case, yes, absolutely. Number two, the presumption of public service is that all members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild then act as public agents of the government or public officials by making additional oaths of the public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under the public oath. Everybody got that one?
Well, I have a question.
Go
So
ahead.
there's the private and they have two different oaths that they take. That's what that says.
They take an oath in private and claim that they're a public office, which isn't true.
Yeah.
But there's he who can be deceived, let him.
And in
And
some
John-
cases, they take an oath to not be under another oath. Right?
Yes, yeah.
And they never deny it.
Yes, they take an oath to their private bar guild, which could be the British Accreditation Registry that we can never get one of them to admit to. But that's what it could be.
As a member,
John Smith said, go ahead.
2,520 years ended in the year 2009. 3
Yes.
years later was 2012. That was the end of
Yes.
it all.
I agree with you, Henry. It's just that I can't prove it and nobody will acquiesce to it.
Well, 1 year notice, 1 year adjudication, 1 year return. That's 3 years. 2012
agree.
occurred. That was
I
the end of
agree.
the bar. That was the end of the bar.
Yep.
Okay, I'll shut up.
No,
Henry.
you're good.
We should definitely go talk to the Oregon Bar Association and tell them that they need to leave.
Yes.
Maybe our courts send them the document.
Hey, that's a good idea.
Why not? We can.
You
We'll make up a document and send it to
There
them.
we go.
John Smith said the undersigned formally challenged the presumption of public service as it is by definition a presumption and has no standing or merit in presentable or material fact. Pretty clear, straightforward denial. Number 3, the presumption of public oath is that all members of the private bar guild acting in the capacity of public officials who have sworn a solemn public oath remain bound by that oath and therefore bound to serve honestly, impartially, and fairly as dictated by their oath, unless openly challenged and demanded. The presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. That's pretty clear. Let's see what John Smith says. John Smith, the undersigned, formally challenged the presumption of public oath as it is by definition a presumption, by definition has no standing or merit in presentable or material fact. Looks like John says pretty much the same thing on every one of them. And he's right. Let's see, number 4, the presumption of immunity is the key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith are immune from personal claims of injury and liability unless openly challenged. Their oath demanded. The presumption stands that the members of the private bar guild are public trustees acting as judges, prosecutors, and magistrates are immune from any personal accountability for their actions. I have a document that tells step by step exactly how to sue a judge or a magistrate. And nobody's rebutted it, and it's worked. I don't want to have to test it because I don't want to go into that law form.
Sounds like a good TV show.
Yeah, really. Let's see. John Smith said the same thing on 4 as he said on 2 and 3. Number 5, the presumption of summons is that by custom a summons unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, witness, and jurisdiction of the court. Attendance to the court is usually invitation by summons. Unless the summons is rejected and returned, with a copy of the rejected filed prior to choosing to visit or attend, jurisdiction and position as the accused and the existence of guilt stands. Wow.
What about the idea of innocent until proven guilty.
Yeah, what
There's a
about
presumption
that?
turned around backwards.
They do that for sure. Let's see. Henry just dropped something in chat. Did anybody see what it was?
I'll look. Factually, he says.
Yes. They're dealing with presumptions. And let's see, John Smith said the exact same thing again. Okay, number 6. The presumption of custody is that by custom, a summons or warrant for arrest unrebutted stands, and therefore one who attends court is presumed to be a thing and therefore liable to be detained in custody by custodians. Custodians may only lawfully hold custody of property and things, not flesh and blood, soul possessing beings, unless this presumption is openly challenged by rejection of summons and or at court the presumption stands you are a thing and property and therefore lawfully able to be kept in custody by custodians. That's a good one. That's where the writ of habeas corpus comes to play.
Yes, and that goes back to what I was saying, is the court, as we know it, is no place for the people. So we don't want to allow ourselves to be considered persons, things, U.S. citizens. We're not their property. We are the people, flesh and blood, spirit, mind, body, soul people. It's an attitude.
Yes.
I recall that court you talk about, Ron, where the judge said that you were a person and you were going to be tried as a person.
Yeah, that's what he told me, and that's what he did, and he gave me 20 days.
Wow.
Didn't make any difference because they upheld it in the appellate court and the Supreme Court. And here's a little something for you. I have 28 judges on Oregon on charges filed into the United States Federal District Court of Portland and the United States Court of International Trade, which is an Article 3 court in New York City. And none of them will provide their proof of jurisdiction in written form into the record of the court, which this says right here they have to do. And they won't do it. And then they won't accept the responsibilities for it. So I made them all defendants. Someday when we get Oregon back, I'll bring those 52 complaints. No, not complaints. 52 claims to our grand jury. But that's another story. Let's see. What did John say? John said the same thing again. John is pretty repetitive.
I'm going to repeat that one last time for this episode.
Sure. John Smith, the undersigned, formally challenged the presumption of custody as it is by definition a presumption, by definition, and has no standing or merit in presentable or material fact. Now we're doing presumptions of court of guardians. Is the presumption that as you may be listed as a resident, there's that word again. I am not a resident. If you're a resident, they'll hand you your ass. Listed as a resident of a ward of a local government area and have listed on your passport the letter P. You guys that have passports, see if you have a P on your passport. That's important. Please do that before we go too much further. Now, Cynthia has 5 stars, so she's an ambassador from what I understand. But in any case, on your passport, the letter P, you are a pauper, and therefore under the guardian powers of the government and its agents as a court of guardians, unless this presumption is openly challenged, to demonstrate you are both a general guardian and a general executor of the matter, trust, before the court, the presumption stands and you are, by default, a pauper, a lunatic, and therefore must obey the rules of the clerk of the guardians, the clerk of magistrate courts. God, they are so wicked. They are evil. He who can be deceived, let him. And we're no longer deceived, therefore we're letting them know that we're no longer deceived, and every time they do, they acquiesce. They have all powers inherent in the people.
I have a P.
Go ahead. I'm sorry.
I have a P.
You have a P on your passport?
I have a P. It says a type P. I'm a P.
Yes. Okay. So then you need to get together with William and refile your papers so that you get to be an A.
I have a P, I believe, on mine. I don't have it in front of me here, but I believe what I recall seeing a P on there. Even though on my card I have 4 stars, there's no P on the card. But
there's
on the passport booklet, I believe there was a P there. And I'm not sure if that P means anything or not. I've heard it here, and I've heard it from a few other people, but never once from the guy that I was dealing with my paperwork that he said, oh my God, you have to get that P corrected. It was never mentioned in the documents that I filed with the Secretary of State, mentioning anything about don't put a P on my documents. But
Cynthia wanted to know where you would look on your passport to find that. And she said she has an A. And I thought, well, A may be ambassador.
Yeah, well,
on her
no
passport card or on her passport booklet?
Good question.
I don't know.
It's on my passport booklet. It's at the top left-hand corner next to my picture. It says type P.
Okay, so then you're a pauper. Are you a pauper?
I thought it meant private. Why does it not mean private?
Yeah, see, I don't think there's a real definition. I think it's a lot of hearsay.
Well, but the hearsay of John Smith is every bit as good as the hearsay of anybody else.
He's like lives right next door to John Doe.
Yes. Okay. Let's see, Cynthia, are you home and do you have your let's see.
No, she's not. She's not home.
On the passport there is no stars. So there's no stars on the passport, only on the card. And on the card, there's no P or A or anything else. But on the passport, there is.
Carol, where's that P at? Describe it to me.
I don't know. I'm just telling you what I got here.
It's right next to your photo is what she said.
Yeah.
On the upper left-hand corner of the information area.
Okay. I'll look when I get home tomorrow. I'll bring my passport, William.
Thank you.
Okay. That one was an interesting one. There should be some action among the listeners to look at their passport and look at their passport card and see about stars and letters, and then contact us. Contact me, and I'll throw William under the bus.
Yeah, I'll post a image of my stars on the show here.
Would you contact your mentor and see what he has to say about it too? Because you
Yeah,
got
I'll
you
do
got
that.
this document there, so you can just cut and paste it for him.
Yep, that's right.
Okay, the
Sounds like-
next one. Go ahead. I'm sorry I interrupted you.
No, it said it would sound like a good idea.
I did
Okay.
want to say one thing, and that is that when anyone actually reads this or takes it in, it's really critically important to recognize what they, the courts, the judges, the attorneys think of us, because it's right there in their words. And it is certainly something that is our responsibility to say, wait a minute, that's not me. I'm not that. I'm a possession. You're not in control or in charge of me. It is an attitude.
Yes.
Yeah, and then also, they start off the whole thing right off the bat with asking you if you're in the courtroom, right? And if you admit to that, you're admitting to be the all uppercase title for a trust. So right off the bat, they try to get you into there, and you can't answer yes to that. You need to ask them to write it out, or maybe you have it written out with the proper English where it's an uppercase letter at the beginning of the name, followed by the lowercase letters, and then each name would be the same. And then you could show them, this is me, right? Instead of, oh, yes, I am here, sir, right?
Yeah, you want to deny that, but you got to be careful because Terry Trussell stood up in court and said, I'm here. The judge refused to see him because he wasn't on the judge's side of the bar.
Yes.
So then they passed a warrant for his arrest, and they arrested him, and he died in jail.
So step across the bar before you address them?
That's what they say. But there was an old man who's dead now named Marple. Dick Marple, New Hampshire House of Representatives. And he was in their House of Representatives, and he was on our side. And he was fighting them every step of the way. It was on YouTube. He was standing outside the bar, hollering at the judge all the way across the courtroom, pounding on the bar between the audience and the court, and all kinds of stuff he was saying. And he was a tough old man. And he kept up until she abandoned the bench. She got up and left the court. She abandoned. Well, he who abandons the field loses.
So my question is, if we announce to the judge that we are not in their jurisdiction, what are the options for their response?
Well, saying it doesn't count. Before you ever get to court, you have to write it out, file it into the court, have proof of filing it into the court and in your possession. Then you got a leg to stand on. Not that they choose to pay attention to it if you cross the bar into their court, because if you do that, well, then they claim jurisdiction.
Oh, yeah.
And here's another thing. I found this out from the attorney I had that was handling my appeal till I fired him. Attorneys always grant jurisdiction to the judge in the court where they're appearing. So if you hire an attorney or one is assigned to you and you accept it, and he goes into that court, he automatically gives jurisdiction to the judge and deprives you of your right to have proof of jurisdiction. So, he who can be deceived, let him. Let's see, what's the next one? The trustee. I haven't done trustee yet, have I? Presumption of the Court of Trustees. It is the members of the private bar guild presume you accept the office of trustee as a public servant and government employee just by attending a Roman court, as such courts are always for public trustees by the rules of the guild and the Roman system, unless this presumption is openly challenged to state you are merely visiting by invitation. Henry told me that one too. By invitation to clear up the matter, and you are not a government employee or a public trustee in this instance, the presumption stands and is assumed to be one of the most significant reasons to claim jurisdiction simply because you appeared. Henry said, I refuse to appear. I am attending under duress, or something like that. He's here, so if he wanted to say something, he'll join. Okay, so let's see. We did trustees. John Smith said exactly the same thing.
Maybe we should read that again since we're continuing on.
John Smith says, the undersigned formally challenged the presumption of trustee, as it is by definition a presumption. By definition, it has no standing or merit in presentable or material fact. John's consistent. He really is. Okay. Here's number 9. The presumption of government acting in two roles as executor and beneficiary is that for the matter at hand, the private bar guild appoints the judge magistrate in the capacity of executor, while the prosecutor acts in the capacity of beneficiary of the trust for the current matter. If the accused does not seek to assert their right as executor and beneficiary over their body, mind, and soul, they are acting as an executor de son tort or a false executor challenging the rightful judge as executor. Therefore, the judge slash magistrate assumes the role of, quotes, true, unquote, executor and has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation. Unless this presumption is openly challenged to demonstrate you are both the true general guardian and the general executor of the matter, trust in parentheses, before the court, questioning and challenging whether the judge or magistrate is seeking to act as executor de son tort, the presumption stands and you are by default the executor, therefore must obey the rules of the executor, parentheses, judge slash magistrate, close parentheses, or you are an executor de son tort and a judge or magistrate of the private bar guild may seek the assistance of bailiffs or sheriffs to assert their false claim against you.
That's one sentence.
Period. Boy, And somewhere I read along, there's a law that states that anything written must be understandable by a 15-year-old.
Good luck with
Yeah,
that one.
good luck. That one's that's a tongue twister. And John Smith says the same thing again. Number 10.
But what he says is, in challenging the presumption of government acting in two roles as executor and beneficiary, that's important. That it's
Yes,
almost like they have to recuse themselves. How can they do two roles? How can they be functioning in both roles? So that's important of that whole sentence long paragraph.
Because they're breaking the law.
Well, if they say it convolutedly enough, then you don't understand it and you just nod and you say, oh, okay.
yes. It's like people, when I try and explain some of this stuff to them, they say, I'm not interested in politics. I'm interested in the score at the baseball game.
One
Okay.
thing I will say that's important also is when you're asked if you understand, do not understand anything.
Ever.
You do not understand.
And you have to. If you don't understand, you have to be made to understand.
Yes, they have to make
Therefore,
it clear to you. That's their obligation.
therefore you're incompetent and cannot be tried.
Right.
When I was at the Bundy trial, no, it was a Bundy arraignment. There was one guy there that refused to have an attorney and said, I don't understand these proceedings. I don't understand these proceedings. No, I don't want an attorney and I don't understand. And the judge just rolled right on to the next one. They don't care. Anna J. Brown, what a despicable person she is. Let's see, number 10, the presumption of agent and agency. In the presumption, under contract law, you have expressed and granted authority to the judge and magistrate through the statement of such words as recognize, understand, hello, Charlie, or comprehend, and therefore agree to be bound to a contract. Therefore, unless all presumption of agent appointment are rebutted through the use of such formal rejections as, I do not recognize you, to remove all implied or express appointment of the judge, prosecutor, or clerk as agents, the presumption stands and you agree to be contractually bound to perform at the direction of the judge or magistrate. That one was clear to me. Let's see.
Yeah.
John Smith says the same thing.
Yeah, it kind of woke me up. I thought, I shouldn't say that I understand, but then I was like, well, maybe I can say I comprehend.
Nope.
Well, it just said I can't do that one either.
That's right. The best thing is if you're an Oregonian, contact one of us, clerk or deputy clerks of the court, and we'll give you a claim of cognizance to supply to that bogus court that you are not one of them, you are one of us, and they have no jurisdiction over you.
Better to not talk to them.
Yes.
And I would like you to please make it clear to those who are watching or listening about our court. What are we?
Well, why don't you tell them?
We are a civilian court of record on Oregon. We are a court of the people. We are a de jure court. We are not a de facto court. We don't hold court on a premises particularly. We don't have a room or a place that we hold court. We have grand jury and petite juries. We do arraignments, and we create presentments and true bills. And we file those. Well, right now, we've filed our first verdict on Kate Brown, Ron Wyden, Jeff Merkley, and Suzanne Bonamici with the de facto DAs. So on every single county. So we are right now at a point where we're waiting to see if they're actually going to hold prosecutions for our guilty as charged individuals who are persons, not people.
Why did you want me to do that? That all came out without looking at a piece of paper or anything. I think you own that, Charlie.
Okay.
Yeah. I think there's probably 10 or 20 of us that
Yes, we
own it.
do.
And we're going for them.
Yeah.
Okay, we're all the way down to number 12. No, here's the other one. I just finished agent, didn't I?
Yeah, we're on incompetence.
Yeah. Smarty pants. The presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to present yourself. They got the word right. It's not represent yourself, it's present yourself. They knew it. And argue properly. Therefore, the judge magistrate, as executor, has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation. Hello, Richard. Unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to any contrary presumptions, then it stands by the time of pleading that you are incompetent, then the judge or magistrate can do what they need to keep you obedient.
Well, it's so clear in their verbiage and their presumptions that we are chattel and that we're just objects that need to be dealt with. So again, our attitude in terms of our position of who we really are, when we know that we're blood, mind, body, soul from our Creator, that's an important position, and we are then sovereign.
Agreed. Let's see, number 12. The presumption of guilt is the presumption that it is presumed to be a private business meeting of the Bar Guild. You are guilty whether you plead guilty or plead not guilty. Therefore, unless you either have previously prepared an affidavit of truth, and I change that to living testimony in the form of an affidavit of truth, and a motion to dismiss with extreme prejudice, excellent, into the public record, or call a demur. Richard likes that one, and so do I. The charges that I'm charged with do not apply in this case. Then the presumption that you are guilty and the private bar guild can hold you until a bond is prepared to guarantee the amount of guilt, the amount the guild wants to profit from you. I'd like to bring another point up here. Maybe you folks don't know it, but there's 2 states out of the 50 states, or the 33 states and 17 territories, that have done away with the industry of bail bond. In any state but Oregon and Illinois, the 2 most crooked states out of all of the states, the industry of bail bonds is handled by the judges on Oregon. They are the ones that run the bail bond business. They're in business to make money on your bail.
So you pull the man out and rake up that money too. They cut out the middle guy and start money off that one too.
Yep. Out of the only two out of all the states, and I'm pretty sure that Oregon is the only one of all the states that keeps the exclusive right to sell hard liquor.
Wow.
Yeah. Wow. Okay, let's see what John Smith has to say. He says the same thing. And then the second thing he says is, I formally challenge all presumptions of law and have formally challenged all 12 presumptions of law, then the presumption of law formally that has no substance in matter or fact. I will recognize the rule of law when and only when there is material evidence of that assumed role of law has some material evidence of substance in presentable material fact. Until then, the search for the rule of law that has some credibility in material fact continues. It is done without ill will or vexation. John Smith, for and on behalf of the legal entity, Mr. John Smith in all capitals, and the living man, John Smith, upper and lower case. I think John did a good job.
So that was good to go through the 12 presumptions. Hopefully that helps out a lot of people out there that have to deal with this, or I don't know, maybe it confuses them a little bit more. Some of the stuff seems straightforward and others don't. When I look at the 12 presumptions, I wonder, do I bring this in with me and just read it all out to the judge and then hand it over to them? How do I rebut this? Is it orally or is it written before I get there? Do I hand it over after I get there? What do you think?
Well, you do it just like John did. You file a written rebuttal to all 12 presumptions. You file it into the record of the court, and you have proof that you filed it into the court. Now, when I first started filing into the municipal court in Beaverton, I would give them 2 originals. They would keep one and stamp one and give it back to me. Then they quit that, and I don't know why, but they quit doing that, and they started filing my paper, taking a photocopy of it, and stamping the photocopy and giving me the photocopy back. But I still had my original, and I put the 2 of them together. But
depends on the court.
Anything
Depends on the court we're in, whether they deal with it one way or another. So basically, we should probably put this on our website for people to download and to adjust with their names on it.
Absolutely.
Okay.
This is a template for anybody that is going to go to court.
So should we do like we do our documents, where we print our name in blue, date it in blue, and then autograph it in red, and then thumb stamp it also?
Yep, absolutely.
Good. All right. Looks like a good show. Yep. Everybody go to our website, orsja.org. You can go to our YouTube from there, Facebook. Our documents will be there. We'll keep adding to them. Go to the blog, join that so you'll know where we're at next time. Thank you.
Thank you.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying, and then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, shot him 3 more times.